What is a non-covered service? A dentist has set fees for their office. An insurance company has a fee schedule that the dentist agrees to accept. Some fees, for example, a crown and restoration, are covered because the insurance company reimburses the dentist. A non-covered service is one that has a set fee from the insurance company, but the company does not reimburse for. This means they are setting a fee that may or may not be consistent with the dentist's fee schedule, and they are not reimbursing for it. 40 states already agree that this is unreasonable and have legislation against it. However, more and more insurance plans are under federal regulations, meaning this act must be passed to apply to those companies and plans. The ADA, along with the American Optometric Association, supports the Doc Access Act, H.R. 1606. H.R. 1606 is narrowly drawn to apply only to dental and vision plans regulated by the federal government. This legislation would not interfere with a state's abilities to maintain and enforce their own insurance regulations and laws, but rather complements the work already done by most state legislatures across the country. H.R. 1606 also establishes some rules of the road for provider network participation. The specifics can be found on the Lobby Day information sheet, in the email, or on the website.